The impact of Brexit on IP rights, that's what we're going to talk about. I'm here with my colleague Henry, who is actually British and who can tell us more about it. UK professionals are telling us that business is still as usual, although the UK has left the EU. Would you say that too?
Well, essentially, the message is correct in terms of European patents because UK remains a contracting state of the EPC, and the EPO is not subject to EU governance. As far as patent litigation is concerned, this takes place on a national level based on the bundle of national patents offered by granted EP. As far as supplementary protection certificates are concerned, authorizations are still currently being issued by the European Medicines Agency. And after the transition period next year, these will be converted to equivalent UK authorizations.
So for SPC, it's what they do for trademarks and designs as well, because it's a harmonized right you get. And there as well, as you just said, the UK has implemented a rule that when you have a registration of an EU trademark or design, these will be automatically converted into cloned national UK rights, a trademark or a respective design. But it's more difficult when you get to applications. Like when you have a pending EU trademark or design application, you don't get a corresponding UK right automatically. You will have to refile it within 9 months after the end of the transition period. That's something to be considered. And also, Brexit does have quite an effect on pending cancellation actions, where you have then two different rights, and when assuming that you have the EU trademark cancelled, this would normally automatically lead to a cancellation of the cloned UK right, unless the EU cancellation is based on a national right which does not at all affect the UK like a German national right before. Also, it's important to consider that at the moment we have harmonized EU rules on enforcement and litigation of EU trademarks and designs, and this will also change because the EU will not have, obviously, jurisdiction over the UK anymore, and you will not have a pan-European injunction anymore, which is too bad, actually. Enforcement will be more difficult because you don't have Brussels regulation anymore, and you don't have these harmonized rules. So all the great effects we had on harmonization, covering also the UK, will be gone after Brexit. So speaking about harmonization, what about patents, UPC harmonization? What is going on there?
Well, Unified Patent Court would offer a pan-European forum for patent litigation. As far as the UK is concerned, it's still up in the air. The UK have ratified the UPC agreement, but even if the Germans were to ratify it, it would still be very questionable whether the UK could participate, given that they're no longer a member state. And secondly, whether they would participate. Given the UK government's current non-alignment with EU stance, a hard Brexit is looking increasingly likely, and then it would be very questionable whether the UK would be willing to participate in a system that recognises the primacy of EU law and the Court of Justice of the EU as the highest instance. This is obviously a shame because if UPC were to come, which we hope, London would form one of the central divisions, and the UK already has specialist expertise in patent litigation and pharmaceuticals.
Yeah. So many things still unclear. I would say not really business as usual. It's important to keep updated on what to do, what the impact of Brexit on your IP rights and its enforcement will be. So check out our website. We will keep you updated. Thank you very much.